Paula Llewelyn QC, and I had to change it to KC.
Oh, so you went to Kingston College?
I went to
Or
their
Knox
sister
College. Knox
school.
College.
I went to their sister school, St. Hugh's.
Well,
So
Knox College
it's not traumatizing to me.
Knox
as
College
it
is
some of
the
my
KC.
colleagues.
That one is a KC.
Oh, well.
Let me ask you. Well, let me not get into that. But the case there in Clarendon, many persons, and as you say, you go by the law.
Yes.
Many persons feel that the young man should get the death penalty. But you're shackled by the law.
Well,
we
that
need to
is so.
understand why and explain to us.
Well, the thing is, because it was in the public domain, because
Right.
the Supreme Court did stream it live,
Right.
then I will just
I love that,
to
by the way.
clarify.
Yes.
It seems to have been well received.
Yes, I love it.
And I'm sure the Chief Justice has noted it, because it could not have happened without his approval.
You can have justice
But
in
I
secret.
think he also feels that in the way that I felt when I became DPP in 2008, that justice can no longer be a cloistered virtue. Where we are now in the 21st century, there is a public clamor for transparency and accountability.
Yes.
It no longer happens that because you have high public office that you can feel that you can go under a rock and just make decisions and people must just take it. We are in a different era now, and I think that those of us in the administration of justice recognize that the public clamor for accountability and transparency has to be respected. So
And
I
they'll return
always
respect the work that
well,
you do.
that is so. They may not necessarily
Agree with you.
agree with the particular decisions, but at least they have an avenue to attempt to understand. Or
And by
to
the way,
understand
I must
my
tell you,
position
Madam
as a matter of
DPP,
law.
that that's about how you might hear persons criticize and so on. I think I'm old enough. You're the first DPP to really come out there and explain to people. That's what we don't do civics at school.
Or are you really trying to say I'm the first DPP to voluntarily put myself on the rack, if I use
Yes, ma'am.
an old expression?
I don't remember.
To be tortured, but it is important.
And what happens is that we learn to have respect. We still vex sometimes when we don't agree with you.
Well,
But
the
it's
thing
not.
about it is that remember, friend, and I
Yes.
tell you, the court of public opinion
Yes, yes.
will always be able, the court of public opinion, which is driven and fed by the media, can always, have that, freedom to express that agony and go
Right.
through that prism. But I don't have that because I'm a
privilege.
creature of the law and we are governed by the rule of law. We are not a banana republic where you can get up and give rein to jungle justice without a thought. We are governed by the rule of law, and those of us who administer the law are bound to apply it.
That case now, I guess you can speak to that because
It was in the public
right.
domain.
Now, why?
What I tried to explain, first of all, there is a case called Jeffrey Perry.
Mhm.
I appeared in that matter in the Court of Appeal, and that was the matter where Mr. Perry was convicted of murdering his 3 young cousins. They were
Yes.
teenagers.
Yeah.
And in fact, what he did, he stripped down to, I think, just his brief before he used a knife and killed them. Yes. And thereafter left the scene, and when there was a hue and cry, returned to the scene fully clothed, as if he was like other members of the public, shocked and wanted to know what had happened.
But he's a great actor.
He was a great actor, and luckily he was caught. He made a partial confession,
Yes.
and he was, convicted. Now, in that matter, the Crown had served what we call the death penalty notice late in the day. This is during the trial. He was convicted, and the judge, senior judge, prescribed in terms of her order the penalty of death, to suffer death in the manner prescribed by law. when he appealed, the main ground of appeal was that, one, given the case law now coming from the Privy Council in a case called Trimmingham and Trimmingham, which was adopted in a case called Peter Dougal, which had to do with the murder of this LG gentleman who he and his girlfriend were sleeping. He owned that gas station.
Oh yes, I don't remember the facts.
Yes, by Dunrobin.
Dunrobin, yeah.
And he was killed in his sleep.
Right.
So they adopted this formulation that the death penalty could only be appropriately considered and ordered if the facts of the case show the worst of the worst and the rarest of the rare in respect of the actions of the accused, and a very important second limb, which is that the Crown, the prosecution, would have to prove that the accused cannot be rehabilitated at all. So that is what the law is saying. So you have to prove those two things.
So it is a law
but yes,
says that Paula Llewelyn KC
not at all. It's not
needs to change.
No,
oh,
it's the law. But that is the law coming from the Privy Council in the case law.
And guess what? Can anybody if you break the law?
No. So you are bound.
You're bound.
To, you're obliged
yes.
to implement it. So what we did is that we had worked with the police, and I have to commend the police because they really were able to work pretty quickly. But they were able to work pretty quickly because they had the cooperation of the public. Oh. They had very good cooperation from the public.
Hold on. The DP, you said?
Yes.
Had the cooperation
of the public.
Who not cooperate?
Because too often, a lot of members of the public who say we want justice, they're like armchair cricketers. Now you know I love cricket.
Or talk show hosts like myself.
You're not going to draw my tongue.
No, I'm telling you.
Critique.
I am telling you.
They sit up in the stands.
Yeah.
They are looking at the cricket pitch.
Yeah.
And they are saying, hold on, but I could do better than that. Right?
I don't care bowler.
I could do better than that.
Yeah,
either as a batsman or a bowler.
As a bowler.
Or they are seeing the batsman trying to dodge some of the pace bowling. Right. And they're saying, boy, man, he's a coward.
He's an idiot.
He's an idiot.
Yeah.
But you put them there, and they will either have lockjaw or they will have paralysis. Right? So, you know, it is a good thing that members of law enforcement.
It reminds me of. And I've fallen into that trap. A whole lot of people say, if you go to the boss and take care of, and if you go to the boss, you know what behind you.
People have to understand when the police are able to bring a quick resolution to an investigation, when you look at it invariably, it's because they have had very good cooperation and good intelligence from members of the public.
Yes.
There are too many pockets of some communities in Jamaica, and I say it, where criminality is accommodated. So when you find these pockets where criminality is accommodated, it means that because the persons in the community have relatives who are criminal in nature, in terms of their actions,
and their son and their boyfriend,
they look the other way. Yes. And then they say, what is the police doing, when they very well know who the perpetrators of the offense are? Yes. So the police, it makes their work that much harder. But in this case, in the Cocoa Piece matter, I can say that the police got very good cooperation from day one. So within, I would say, and then about 2 days after, when they reached out to me, I was able to assign a deputy director to work with them in terms of case conferences. Now, case conferences are very good in matters that are complex, especially because from day one, the police are able to get the benefit of our advice. We know the case law. We know the kind of hurdles and challenges you are going to have when you are going to prosecute the matter.
Yeah.
Because remember, the prosecution has to prove the case beyond a reasonable doubt. That's a very, very high standard.
Beyond a reasonable
doubt.
That's right.
So the court of public opinion can afford to use susu
I him
or
do it. In
veranda
guilty.
gossip
I in guilty. I him do
or
it.
feelings.
Yes.
Or they say, boy, gut feeling, or I have a feeling that he did it. But we can't take that to law. You can't stand up and tell the court that because a member of the public said that they have a feeling, or the police investigator had a funny feeling that is really A did it, or B, that cannot go to court.
So just answer like what? Hearsay can stand up.
Hearsay can't go to law.
So gut feeling.
So no, gut feeling can't go to law. You need cogent, credible, reliable, admissible evidence.
And the police don't. This is where the police probably ought to play a better part in terms of how they collect the evidence and
listen,
what is a tamper.
Vernon, the police are investigators. They are not dentists. They can open your mouth and extract the material out of it.
What are we?
You have to cooperate to give that statement to the police.
But you're afraid they'll come for you, madam.
No, but also, but you try to do it. You try to do it confidentially.
Yes.
There are so many quarters.
But why are we faithful that we're not going to dead one day?
But I'm telling you, some people, I'm not saying some people may not be, not have a right to be afraid. But I have found sometimes, and the police will say it, when you really penetrate it, what the people are not telling you is that everybody in the yard are connected, or the next door neighbor, they are all connected. This one is sleeping with that one is cousin to that one, second cousin. And at the heart of it, some of elements of criminality are there, so they don't want to appear to be giving intelligence or information about a relative who may be in a criminal setup. And what will happen is not until the persons turn in on them, right? And when they hear there's been a massacre, 4 people killed.
My mother
reprisal.
Too late.
But that's exactly it. And the police keep trying to encourage people to say, listen, do not harbor criminals. Do not know that you have relatives who are in criminal enterprises or gangs, and you harbor them, because what will happen, to use the Jamaican parlance, some of the persons who have something against them will say, if you can't catch Quack, you can't get that person.
How we don't learn that?
And I've prosecuted cases like that.
How we don't learn that?
I have prosecuted cases like that, and it is such a tragedy.
Yes.
I have prosecuted cases where children have been killed, adults have been killed, and when you check it out, the family had some son who doesn't live there.
Yes.
But he comes there and takes refuge occasionally, and he's a member of some gang. And then, unknown to the family, he has committed some murder against another gang. And then he goes into hiding. But the persons know that this is where his mother lives, and his stepfather or his brother and sister. And what they do, they say, okay, he's keeping out of hearing. Well, I am going to deal with him. And what they do, they go after the innocent members of family in order to hurt him.
When they leave it today, they're going to sing upon something.
So people have to understand that it is important that it doesn't matter where criminality comes from. Right is right and wrong is wrong. And you find a way, some do, to give that information. Right? But do not harbor persons that you know
the same knife and
are
stick.
criminal. It happens. It's very, very unfortunate and very tragic. So back to the Rasheen Barrett matter. So what we did, once we are in discussion with the police in terms of case conference, and we know the type of injuries, we know what the fact pattern is, the narrative, we realize in our view that this was the worst of the worst and the rarest of the rare. So immediately you think, okay, there's a possibility that if it goes to trial, that we will indict for a death penalty murder, 5 counts.
But you will not face a death penalty.
Just a moment. It's still on the books.
It's done.
Right? Remember, I am not an academic. I am not a journalist. I operate within the context of the law that is on the books, right? It has not been repealed. But the law says that if it's going to be a possibility at a sentencing hearing, then we are bound to file a death notice. That case, Jeffrey Perry says it, at the earliest opportunity so that the accused becomes aware that if you go to trial, so if you plead not guilty and you go to trial,
then
at the sentencing hearing, there are 2 possible sentences that you can get if you are shown to have committed an offense which is the worst of the worst and the rarest of the rare, and that the Crown can show that you cannot be rehabilitated. Then you will face either the possibility of a death penalty being pronounced or life imprisonment and a term of years before you get parole. So what the law is saying, you can't wait until when the verdict comes back and say guilty, and then you file the death notice. You say, based on the evidence, this could possibly be a death penalty case. You can't do that.
You have caught the defendant by surprise also.
That is it.
Right.
That is the essence of it. Because all the laws now at this time emphasize that the underbelly or the main criterion that the courts look at to see whether there has been correct administration of justice or a miscarriage of justice is fairness to the accused.
So is that only fairness to the plaintiff?
Well, I'm going to tell you, first it's fairness to the accused, then fairness to the victim.
Well,
it's fairness to the accused because remember, the prosecution, you remember under the Constitution, you have a right to due process of law. That's constitutional. That's a constitutional.
The right to a defense lawyer.
Right? You have a right to defend yourself properly. It's practically a right to have proper representation before the court. So the prosecutor, not only the judge, but the prosecution, meaning the prosecutor and the police investigators or law enforcement and defense counsel, have the preeminent duty of making sure that wherever you intersect with the accused, you have been very fair.
By the way,
that's the criterion.
There's one thing was start to continue, but to give thanks for. I always have a problem with that. Why them can appeal their judgment and you can't appeal?
Well, we can now appeal.
That's what I'm saying. I've always wondered why.
Yes, but
the
defense, I can say my friends.
Yes.
My colleagues at the defense bar, they fought it over the last
Why would they
years.
do? I know, but Madam DPP, why would they do?
It's too long to go into.
I know.
But the Parliament have now enacted the legislation which allows, in limited circumstances, the prosecution to appeal. So we have appealed. The first appeal, I did the matter.
Yes,
in Del Powell, where we are appealing sentences given to the accused in 2 murders, which we consider to be unduly lenient.
And that is what they're going to wear. Justice for the plaintiff is the same thing as justice for the defendant.
Well, so the court reserved their judgment, and I believe they are going to come because it's going to be a very important and critical judgment.
It's a landmark.
It will be a landmark judgment. So we are looking forward to that. So we are hoping that by the end of the year.
There are some questions I've been asked, and boy, time this now. You need a regular program.
Yes, but let me finish the Rashid Barrett matter.
Right.
So once we got word, I brought it up on a voluntary bill of indictment, which is only the DPP can do that. So the case reached the Home Circuit Court roughly a week and a half from the time of the incident. And of course, here the members of the public applauded the police and the authorities with that, but that's okay.
But I did this, don't listen to me. Madam DPP, don't listen to me.
I'm at work. I don't have the time. But the thing is, we did a very good job in terms of the consultation. And as I said, we had a lot of cooperation from the public from day one. So even, for example, the shorts, the shorts and the knife that were found, people were able to identify that they saw him wearing the shorts. People were immediately able to say from day one, the day before, we heard him talking about going to kill persons.
Really?
So the cooperation to the police was first class.
I see.
Right? So he really had no room to hide. No room to hide whatsoever. It was just a matter of time.
The role of the public.
The role of the public in giving information, critical.
Mm-hmm.
So when he pleaded guilty through his attorney, he would have consulted his attorney, and he pleaded guilty at the first opportunity.
Mm-hmm.
The prosecutor, the prosecution, has no basis in law to reject that plea. So we would be obliged to accept that plea.
Yes.
Because remember, we are governed by the rule of law. So once we accept the plea of guilty to those 5 counts of murder, what it means is that we are obliged to give him a certain credit. In all the jurisdictions where the death penalty is still on the books, what the case law would say, the law would say, the credit would have to be to take the possibility of the death penalty at sentencing off the table.
Right.
So it's a matter of
That's
law.
that's a Jamaican thing.
It's not a Jamaican thing.
No.
Wherever you still have the death penalty,
Right.
that is what would happen. So I am shackled. See, I'm pulling my hand. I am shackled by that law.
Shackled
It
by
matters
that.
not what is my personal opinion or what is the personal opinion of the public. We respect the personal opinion of the public. We can empathize, understand, but I'm shackled by the law.
Let me ask you
what
another
I am
question.
glad about
Yes.
is that he accounted to the public and indicated that I am guilty before the funeral of those children and their mother. So at least there was some amount of closure that here it is, in the face of the public, he did say that I am guilty.
I hope if I had money, you see, we are going to retire. I don't believe you don't feel retired now. You're still.
You don't think I look old and beat out
No
and
man,
tired?
no man.
You know, Vernon,
Yeah.
a gentleman said to me in the supermarket a few years ago, when he came up to me and he said, Miss Llewelyn, I like your smile. I get a lot of teasing with the open.
Oh yes, I know. Yes.
Right? And then he paused and I noticed, I was there looking to take something off the shelf and I said, sir, is everything all right? And then he put his arm on Kim and he said, but what a way the stress agree with you. Right? So,
that's true.
although sometimes, I supervised when I took over
Right.
as DPP. We only had about 25 lawyers. I know I have brought it up to 58 lawyers.
Right.
So I supervised 57 lawyers at the office of the DPP. And unlike some other Caribbean prosecuting agencies,
Yes.
we prosecute all of
their
our
cases.
complex matters. We don't farm them out. I'm also the designated central authority for mutual legal assistance, hence traffic bureau.
Oh,
and
that is
matters
why,
like that.
yes.
Right.
But
And
you have
I'm
plenty to talk to us about,
and
too.
I'm also the competent authority for extraditions. So we act for the requesting state. So all the extraditions that you hear
have to come
about,
to your office.
we are the ones who go to court and represent the requesting
All right.
state.
Have to go for the break now. And some questions are being asked out there in terms of the Olin case and those cases. They felt that your office could have done more because of many persons have lost their money. But then I blame them
Vernon, we cannot make up evidence.
All right, gonna go for the break. I want to speak to that because there are people
Yes.
gobbling out there and so on about the Olin case
Yes.
and the other cases, and then you can talk about that. But let me tell you